Yesterday, we talked with Ilya Shapiro, director of the Center for Constitutional Studies at the Cato Institute. And we talked about a few different issues. We talked about the Bostock decision, which everybody's been discussing. That's the Supreme Court decision dealing with LGBT discrimination in the workplace. We also talked about police qualified immunity and the Second Amendment. That is the constitutionally protected right to keep and bear arms. This is fundamental to what it means to be free here in the United States of America. We are able to exercise our right to self-defense. Here in this country, we value the ability of the individual to protect themselves. We value the ability of the individual to access firearms. That is something critical to this country. And by the way, we just saw riots across the country, which emphasize the reason why we have a constitutional protection to keep and bear arms. The reason being, if somebody is going to try to loot your property and will do anything in order to get stuff from inside, including possibly beating you up, as we've seen some of those examples in the recent riots, you ought to be able to defend yourself, especially when you cannot just count on the police to show up. That's what we saw when we talked with Rick French, downtown Raleigh, North Carolina. Absolutely devastated. If Nathan Matoush, if you could find the video of downtown Raleigh from a couple of weeks ago, when the riots were happening, and we had Rick French on this program, and he said for the first time, except for maybe a corporate outing, he held a loaded firearm because his nephew came to provide some protection because the police were nowhere to be found, and that was the only way that they could secure his business. Otherwise, it would have been absolutely ransacked, he said. Not only that, but Rick French said that he, if I recall correctly, had an AR-15. That was one of the firearms that his nephew had brought. Without the firearms, he said, he would not have been able to protect himself and his property. But he did. He was able to do that. And, I mean, if we look at this situation, from Raleigh, from numerous parts of the country where there were no police to be found, you needed to be able to protect yourself. So the Supreme Court had 10 different cases. The United States Supreme Court had 10 different gun rights cases before them that they could have taken up. And the court, as we talked about with Ilya Shapiro yesterday, declined to take up a single one of them. Now, that's significant because what we have in the United States of America right now is a patchwork of understanding among courts across the country of what the Second Amendment means, especially because we have the two decisions of Heller and McDonald, which affirmed a constitutionally protected right to keep and bear arms. Affirmed that that is what the Second Amendment says. One petition that had been presented to the court for the court to take up and hear the case was in Rogers v. Gruel. This is about a New Jersey man who, quote, runs a large ATM business that causes him to frequently work in high crime areas. He wanted to be able to be allowed a handgun, to get a handgun permit in New Jersey. According to the request, he had, quote, met all the eligibility and training requirements. However, in New Jersey, a so-called justifiable need is required to present in order to secure a firearm, a handgun to carry. Justifiable need for, quote, urgent necessity for self-protection as evidenced by specific threats or previous attacks. This guy's handling large sums of money, runs an ATM business, and he had to go on bended knee to the state of New Jersey and present his argument that, yeah, you should give me a firearm. I need to protect myself. But it is not urgent necessity for self-protection as evidenced by specific or previous attacks. We have seen that appeals courts have different views of how to interpret this. Again, we talked about this with Ilya Shapiro yesterday. Whether such tests to carry a gun are permitted. You can't have different appeals courts making different determinations about what the U.S. federal Constitution says in this regard. That kind of patchwork is fundamentally problematic, and it's just plain wrong. Which is why you had the likes of Justice Thomas, who was joined in part by Justice Kavanaugh, argued that this is wrong in their dissent. Quote, "It seems highly unlikely that the court would allow a state to enforce a law requiring a woman to provide a justifiable need before seeking an abortion. But today, faced with the petition challenging just such a restriction on citizens' Second Amendment rights, the court simply looks the other way." Justice Thomas dissenting on the Supreme Court's failure to take up this case among 10 different cases. Another one that they rejected was Warman v. Healy. This was about a Massachusetts case in which the state had banned the use of so-called assault weapons, including the popular AR-15 rifle. Now, one of the things that is important to know about the way the Supreme Court in the past has interpreted the Second Amendment is that a firearm, if it is in common use, is protected under the Constitution. Well, an AR-15 is in common use. And yet, the courts there, the First Circuit Court of Appeals, is not right on that point. We're seeing division among the courts around the country on this interpretation, and the Supreme Court declined to take it up. You should watch more of our interview yesterday with Ilya Shapiro of the Cato Institute, where we talked about this in more depth. But the bottom line is that it is rather irresponsible, it seems to me, that the Supreme Court would decline to take up 10 fundamental cases, critical cases, about a fundamental basic right guaranteed in the U.S. Constitution, the right to self-protection, the right to keep and bear arms. It is a shame that the Supreme Court decided not to resolve these disputes, and Justice Thomas is absolutely right. If this had anything to do with abortion, you can bet your bottom dollar that the United States Supreme Court would be taking up this issue. They chose not to for whatever reason on the Second Amendment. I hope when they're presented with an opportunity in the future, they don't make the same mistake. We need some certainty, and we need to protect and ensure the guarantee in the U.S. Constitution that we, as free people, have the right to keep and bear arms. Because we ought to have that right. Again, as individuals, we say on this show, who are free to think, free to act, and free to choose, we should be free to defend our property, our persons, and our families. Thanks for watching this clip of Jimmy at the Crossroads. Don't miss more engaging, intelligent talk. Subscribe today to the Jimmy at the Crossroads YouTube channel. You do not want to miss our live show. Thanks for your support.
I got Jimmy at the crossroads, making sense out of no sense. Yeah.